and Tapwat Kombucha for sponsoring this education webinar. Today we will be hearing from 4 presenters who I'll introduce in a moment. We're happy to answer your specific questions today, and at the close of the presentations, the format will be open for Q&A. Please email any questions you may have throughout the presentations to either Haley at the chitty@ahpa.org address or via the chat box, and I'll read them without attribution during the Q&A period. Questions will be answered in the order received, and our presenters will do their best to answer all questions during the call. If your question is not reached, the presenters are willing to take inquiries directly from you, and their contact information is provided in the slide deck. Now I'd like to introduce and sincerely thank our presenters for their time, efforts, and for sharing their expertise in creating and presenting these materials. We'll have presentations today from Justin Prochnow. Justin is a shareholder at Greenberg Traurig and focuses his practice on regulatory and business issues, primarily in the food, beverage, medical device, drug, and cosmetic industries. He works with dietary supplement, sports nutrition, beverage, conventional food, cosmetic, medical device, and OTC drug companies to ensure compliance with statutes and regulations enforced by the Food and Drug Administration, the Federal Trade Commission, and other regulatory agencies. Will Garvin is also joining us today. Will is a shareholder at Buchanan, Ingersoll & Rooney and focuses his practice on issues related to the regulation and promotion of drugs, medical devices, dietary supplements, and foods. Will has extensive experience in assisting companies with complying and contesting administrative agency actions of the Food and Drug Administration and the Federal Trade Commission. Will is a member of the Drugs and Biologics Committee for the Food and Drug Law Institute, as well as a member of the Legal Advisory Council for the Natural Products Foundation. Will has presented at KombuchaCon 2015 and KombuchaCon 2014 and has served as part of the compliance program teams for both Supply Side West and Ingredient Marketplace. Robert Lehrman is also joining us, and he is the principal attorney at Lehrman Beverage Law, and his practice companies on the production, labeling, advertising, and taxation of alcohol beverages. He works with clients on product formulation to ensure products are taxed and labeled in an advantageous manner, and assists clients with label review and design to ensure prompt approval. Robert frequently engages with TTB, FDA, Customs, and other agencies on behalf of his clients. Pete Evich is with us, and Pete is the Vice President at Van Scoyoc Associates. Pete has 20 years of Capitol Hill experience and is a Vice President at one of Washington's top lobbying firms. He is a leading policy expert in integrative health and serves as a voice in D.C. for long-established trade associations in both the dietary supplement and the homeopathic drug industry. We also have Art Libertucci with us today, and Art is a senior consultant with the Buckles Group in the Washington, D.C. metro area. Art has previously worked in the Bureau for many years and has great experience in formulating government policy and working with the alcohol beverage industry. Thank you all for sharing your expertise today. Just a reminder before we begin that the American Herbal Products Association is pleased to provide the information to be presented in today's seminar, and though the presenters are considered to be experts in the areas in which they will be presenting, their comments may not necessarily reflect the opinions and positions of AHPA. All materials are copyright and the property of AHPA and may not be reproduced without the express consent and permission of the association. And with that, let's get started. Justin, I would like to turn the floor over to you.
Okay, thank you very much. We're going to start off maybe somewhat easy here with the bottle bill laws and then move on to some more specific things as we go along. And I will turn it back over to Tammy.
Excellent. Thank you, Justin. I must confess, I was not familiar at all with the particulars of the web of bottle bills, so thank you for that. Next, we have Will Garvin. Will?
Yes, thank you so much, Tammy. And just to echo what Justin was saying, Justin's Law Guys Corner is really excellent. So I read it all the time. So if you're interested in beverage law, definitely pay attention to that. I will be presenting today on federal food labeling rules and requirements. So I'll just get started. Let's go to the next slide. So what I'm going to try and do, federal, and with that, I will turn it over to Robert.
Good afternoon. My name is Robert Lehrman. I'm a lawyer at Lehrman Beverage Law, a law firm in the Washington, D.C. area. I have focused on the federal regulation of beer, wine, and spirits since about 1988. On most days, I deal with beer, wine, and spirits, but today it means kombucha. I will look at it mostly from the TTB side of things. Many thanks to AHPA for setting up this webinar. Next slide, please. Okay, so kombucha law, as we've seen so far, can be quite confusing. Nevertheless, it's important to make sure you get it right. The consequences can be really large if you mess it up. There are big potential penalties for getting it wrong, as the next slides will show. TTB made this even clearer a few weeks ago when the agency updated its kombucha pages as shown here on the slide. The part in yellow mentions that criminal penalties may apply. The document also tightens things up by saying it is not going to work for an errant producer to simply blame a retailer for improper storage or to say alcohol beverage testing is hard. As a point of clarification, TTB and ATF are the federal agency. It's the same agency. It's the agency that handles most beer, wine, and spirits things. It's part of the Department of Treasury. It's got about 550 employees, and it was called ATF until about 12 years ago. Next slide. One back, I think. Yeah, it should be on 38. Okay. So far as I can tell, kombucha started getting popular in the late 1990s. I don't think the federal government had much to say about it until this document on the screen in 2006. Here, ATF assessed a small fine against an early kombucha producer. I don't know if you can see it, but it says $2,500. The basis for this offer and compromise is that the kombucha seemed to be over the key 0.5% alcohol by volume threshold and potable, such that the product needed to be taxed and regulated much more like beer and much less like Lipton tea. I probably would have expected the settlement to be much larger because the issues are really big, as you can see in yellow, things like labeling, the government warning, licensing, taxes, typically things the government cares about quite a bit. But then again, on the other side, kombucha sales were probably pretty small way back then in 2006. Most people had no idea what kombucha was, let alone how it should be regulated. I think it's kind of a funny coincidence. I just noticed yesterday that at the bottom in yellow it says TTB, the proponent, is in the business of producing herbal beverages. So, they weren't even clear that it was tea or fermented tea or whatever the heck it is. Okay. 4 years later, in 2010, was the big kombucha recall. What happened is some regulators saw that the problems noted on this document did not go away. And as a result, many retailers removed the product from sale, such as Whole Foods, removed it until they had enough assurances that the product complied with the various rules that we're talking about. Next slide, please. Okay, so what is it? We have some very old rules that were probably not designed with kombucha in mind. The current system really does make it hard to see what box this fermented tea should go in. I found it amusing that one of the other speakers mentioned, what box to put it in. It seems to be the obvious and right little metaphor. The right box is crucial in order to know what rules get triggered. In many instances, the wine rules differ from the beer rules, and so on. Kombucha has the fun distinction of fitting or almost fitting in more boxes compared to most other foods and beverages. So this might come up later in the questions. I sort of feel like kombucha can go in a lot of different boxes, maybe even at the same time. But I think one of the other speakers said, in general, the government is not fond of that approach where it fits more than one category. Okay, next slide, please. The one thing that's easy is kombucha is pretty clearly not a malt beverage. And the reason for that is you can see it in the yellow where the TTB regulations for labeling define malt beverage. They happen to define it as including hops and malted barley, things that something like Budweiser would have, but kombucha almost never has. So let's see, this is 27 CFR Part 7, the beer labeling regulations. Because the fit is not good, what happens is the laws here, like Part 7, the labeling rules, don't get triggered. The other ones that don't get triggered are the tied house rules. And then for those outside the alcohol beverage world, tied house rules are the ones that say, for example, Budweiser should not be allowed to own part of the neighborhood bar or provide things of value to the neighborhood bar. Now, they provide neon and stuff, but those are all exceptions. Okay, next slide, please. So if we don't have a malt beverage that we're talking about, and if it's not a wine or a distilled spirit, let's see if it fits into the category of beer. Bingo. TTB tends to view most kombuchas as beer. TTB's definition of this term is here on the screen, in the center, and it's a pretty good fit. There is a distinction in the beer versus malt beverage terminology because beer is the term used in the tax rules under the Internal Revenue Code, and malt beverage is the term used in the labeling rules because of, right after Prohibition, the law to regulate beer, wine, and spirits. I should say malt beverages, wine, and spirits. Two different statutes passed at two different times is what we have. Note that the center definition requires the product to be 1/2 of 1% or more of alcohol by volume. This is the key threshold that I'll keep coming back to and that other speakers mentioned. It comes up again and again. If the kombucha is lower, it would be a cereal beverage. And I have an example there that I just found at the last minute, the postum there. It's pretty hard to find an example because I don't think anybody's making any big money with cereal beverages. That was big at World War II time and just before. It was not easy to find a good example. And I believe stuff like postum and other cereal beverages were big during Prohibition and during periods of rationing as substitutes for coffee and beer. To make all this even more confusing, it is entirely possible for kombucha to be above and below the key threshold. This happens when the product is above 0.5% during production, as is common for kombucha, but below this number at retail, that is, when ready for consumption. This really confuses a lot of people. Every time I've had to talk to somebody about kombucha in the past year, they just want to know if it's above or below, and a lot of times it's more complicated than that. It goes above and below the key threshold. Okay, slide 42, please. Thanks. To add to the fun, I am sure kombucha is a food for various purposes, as I think William talked about. I suspect it comes close to being a nutrition supplement too at times, but that's not my area, and I'm going to leave it to Will Garvin and to Justin to figure out when it comes to food, supplements, and things other than beer, wine, and spirits and malt beverages. TTB does have primary labeling jurisdiction for most beer, wine, and spirit products, but not for beers without hops and barley. Therefore, most kombuchas default back to the more general FDA food category for at least labeling purposes. Next slide. Don't be alarmed about the gun image on the screen. It's there to get across the point that all this classification stuff is important because it controls what rules get triggered. Once you're sure it's beer, the product would trigger all those 5 or 6 things listed up near the top. I'll go through each of the bullet points in a moment. Note that even if you're a cereal beverage, you are not entirely off the hook either. For the purposes of this list, I will assume all the way down, I'm going to assume the kombucha is over 0.5% during production. The cereal beverage, though, would be below 0.5% after bottling. By contrast, the longer beer list assumes the product will hit 0.5% or higher at some point after production. Okay, slide 44, please. The gray box on the left shows where we are as I go down the list on the various requirements that get triggered. The moment you say it's beer, you will probably need a TTB brewer's notice. This is similar to a liquor license. It can take 3 to 6 months to nail this down, and so you need to start early and allow a lot of lead time. There's no TTB fee for this. The brewer's notice application is not particularly onerous, but you do need to explain how the ownership works, and some people are not used to this level of disclosure. Also, you may need to ensure lots of separation between the beer premises and other activities. Next slide. On formulas now. You probably need a formula approval if you're up there in the beer category. This entails submitting a detailed ingredient list through TTB's internet-based formulas online system. You can be vague about some things like various ingredients, the ones that are not typically highly regulated like sugar. You can just say sugar, but you do need to provide a lot of details about other ingredients, such as, for example, flavors. You can't just say natural raspberry flavor. You've got to provide a lot more detail. Who makes it? How do you know it's natural? That sort of thing. You also need to provide the use rates, perhaps a range, 1 to 2% of IFF raspberry flavor number 12. Get used to waiting because this process, the formula process, takes another 8 to 12 weeks. Plus, you may need one formula approval for each unique product, and you can't even start any of this, the formula stuff, until the first part, the brewer's notice, is done. TTB uses this tool, the formula tool, to sort out whether your kombucha is beer or wine, basically to figure out which box it goes in. It's very important to them. I think way back 20, 30 years ago, it was simply called the commodity classification branch of Department of Treasury. Let's see. And one thing that surprises a lot of people is, you know, a very competent producer often thinks they're going to tell the government what it is because they make it and because they're experts. But it doesn't really work that way. It's more like the government will say, you know, the government will tell you, the producer, what box they think it goes in. And you're kind of stuck with it at least for a while, even if you don't agree. Okay, next slide. All right. Lest in case you need some relief right about now, at least you don't need label approval. That would otherwise add another several weeks and some haggling to your wait times. Now, it's not all good news because this does mean the label review is entirely on you and your consultants and advisors. That's not me. By contrast, all spirits labels need TTB pre-market review and approval. But most spirits companies sort of like having the TTB and label approval system, even though it's often slow and frustrating. That's because you can push the burden of review off onto the government instead of onto William or me or Justin, etc. You know, the government does some of that work for you, even if you don't always like the result. When TTB approves your label, even if the label is dubious, you can then argue that the label is protected in a, quote, safe harbor. That's what the famous Tito's vodka case is all about. That is, TTB approved the Tito vodka labels over and over again over the past 20 years. The labels happen to say handmade in big letters on the front label, but in many lawsuits over the past year or so, the plaintiffs are saying that term is misleading on this label, or that it's impossible even to be handmade because the brand is super successful and is way over 1 million cases per year. So something like 18 million bottles. Okay, next slide. 40, yep, that's good. So we're on to the GWS, the government warning statement. That's that long one that's on most beer, wine, spirits. Most people are used to it. It came around in about 1988 or so. Even though TTB does not have direct control over most kombucha labeling issues, you still need a government warning, regardless of all else, if the product is at or above the key 0.5% alcohol by volume threshold. That's the 41 or so words you see on every bottle of Budweiser. It begins with, in bold print, government warning, colon, blah, blah, blah. This applies widely because it stems from a slightly different law, the 1988 Alcohol Beverage, it's called ABLA for short, ABLA. It's not based on the FAA Act, which is the basic label and permit law enforced by TTB, and it's not based on the Internal Revenue Code. The penalties can be massive under this law if you blow it here. At the right, in yellow, where it talks about civil penalties, you can see where the regulation says the penalty is up to $10,000 per day, and this is not just per company, this is per day, per unique product. So for example, if you have a pear kombucha, a persimmon kombucha, you know, really the numbers are endless, and the law does say shall be subject. So perhaps it's even, you know, it's just a matter of time before somebody gets slapped with that, probably. All right, unlike the finicky malt beverage rules that require a particular type of bitter flowers, that is hops, the Part 16 rules simply require the warning on, quote, any beverage, end quote, with more than 0.5% alcohol by volume. Like I said a minute ago, it's just a matter of time before somebody gets blasted with this powerful device. Next slide. Okay, excise tax. There's lots to do because you still need to pay excise taxes if you stay at 0.5% or above after production and bottling. The taxes are shown on the slide, and on a per bottle basis, it's something like about 2 cents per bottle. That assumes a 12-ounce bottle of kombucha, you know, maybe 3 cents for the larger bottles. Also, depending on the state law, you might have a state tax on each gallon. The range on these state taxes is pretty wide. I found 2 states that are above $1 a gallon. that is Tennessee and Alaska. I think we're about $1.07 per gallon. And on the low side, Wyoming is only 2 cents per gallon, 1/50th as much. I'm sure the penalties can be large also if you blow it on the tax and either don't pay at all or pay the wrong amount. Next slide. So I think the point is coming across that beer is one of the most heavily regulated consumer products in our society. There's another layer too that makes this so. Mostly we've focused here today on the federal rules. Justin focused on state, but I think William and I have been focusing on federal. But now you really get into the messy part where you've got 50 different states regulating 50 different ways. And it's really rare that even an alcohol beverage lawyer knows all 50 states, times beer, times wine, times spirits, times imports, times domestics. It's innumerable permutations. So that's expensive for clients because, you know, there's very little repeat fact patterns. Okay, so why is it this way with so many different states and rules? It's because the 21st Amendment and the FAA Act provide so much authority to the states on beer. The probable rationale for that is that long ago when all these rules were promulgated, almost 100 years ago now, beer was usually regarded as a local beverage. You know, maybe spirits was coming from France even way back then, or the other side of the country, perhaps wine, but beer was very often from down the street, and the law reflects that. Listed some of the state rules that may apply. They're on the slide above. For example, your retailers can't sell the product to minors, and they have to have the right license. So if you think about this, if you in fact have a beer and you're over 0.5% and you need all this regulation, if you don't tell your wholesalers and your retailers, they have almost no chance to get it right. And I'm not sure really who gets the finger pointed at them if that occurs, but it's going to be a messy situation if any retailer is selling, quote, beer to, for example, minors and doesn't even know that it's beer. Let's see. So other things that I listed on the slide, in many states, if not most states, there are very strict laws to require that all beer has to be sold through wholesalers. And they're not fooling around. I mean, that's how they make their money. They're powerful within their states. They just, a long time ago, they nailed this down where you have to go through them, and it's a serious violation if you don't. This is the famous three-tier system that you might have heard about. It also means the middle tier can take a juicy cut of your profits, and probably will. It also could mean, due to franchise law protections, that you and the wholesaler are in a long-term marriage that you can't get out of. The idea there is once you appoint a wholesaler, it gives that wholesaler certain rights, and you can't just say, I changed my mind, or you're not doing a good enough job. The law is much tougher than that, and you're kind of stuck together to the point where typically, if you want to change wholesalers, you have to negotiate and pay your way out. Okay, so slide 50, please. Okay, so now we're onto cereal beverages. And there's really only one thing that I saw that you have to do, at least labeling-wise, for cereal beverages. Even if your kombucha is always below 0.5% alcohol by volume, after bottling, there's at least this one oddball labeling rule that may apply. I don't know if you can read it in yellow, but it says you have to say on your package someplace, front or back, non-taxable under section 5051 IRC. IRC is the Internal Revenue Code. I don't know if I'm supposed to be timely, but last week it caught my attention. Carly Fiorina was complaining about the tax code. And by the way, this is not a political statement. She, was criticizing our ridiculous system in the Internal Revenue Code, and she said it has 73,000 pages. I looked that up the other day to see what the internet said about that, and somebody on the internet pointed out that no, it does not have 73,000 pages. The Internal Revenue Code only has 5,000 pages. So the way this shapes up, a good little rule of thumb here about what sort of warnings you need and labeling you need, you probably need one or the other. Either you need that long 41-word government warning statement if it's above 0.5 at retail, or even 0.5 exactly. And then if it's not, if it's below that, then at a minimum you need the 5-word one on the screen in yellow saying non-taxable. So a cool thing about that is nobody should have to guess. Every single kombucha should say sort of like one or the other warning. Okay, next slide. And by the way, it may be worth pointing out, I have a feeling like almost no kombuchas do this currently. I can't think of any that have the government warning on them, and I also can't think of any that have the IRC warning. The IRC warning is not obvious at all. I think it was Art Libertucci, who's on the call here. I never thought about it until Art mentioned it about a week or two ago. He was digging through the regulations and noticed it. Okay, so on to slide 51. So this stuff is not just theoretical. It's starting to get traction. It's starting to percolate into the news and certainly into the courts. Lest there be any doubt that the stakes are high, the trial lawyers recently piled in to the kombucha industry. In this Retta case, it was filed in early 2015, but then it took a very sharp turn about a month ago, where the claims got amended. They started with being related to antioxidant claims, and then they shifted toward, but it's got a fair amount of alcohol in it, more than 0.5, and perhaps isn't labeled properly. Okay, so in this Retta case, a consumer went after one of the big brands in early 2015. It went from bad to worse when the Retta plaintiffs amended their complaint on 10/8/2015. They added allegations that all or most of the products are loaded with well more than 0.5% alcohol. So really, their entire line. The complaint explains that the defendant ignores most of the beer rules we've been talking about. This case could have enormous consequences for really everybody in the kombucha industry. And this might be why you're starting to see things like the AHPA webinar, things like Congressman Polis is jumping in to get involved, and TTB is getting much more vocal also, and kind of beefed up their kombucha page to make a lot of stuff clearer. One thing they made clearer is it's not going to work just to blame, to make kombucha, then sell it, and then if, for example, it continues to ferment, you can't just blame the guy that bought it and said, like, hey, Susie Homemaker left it in the minivan for more than 5 minutes, and that's why it fermented. That's not going to work. TTB said it's so foreseeable that the kombucha industry needs to take responsibility for those sorts of things. Okay, so slide 52, please. There are really a bunch of other lawsuits. They have not been in the press much, so I'll briefly describe them. Let's see. The 2015 Retta case is similar to these cases on the screen. These are from way back in 2010. There are about 4 of them. They popped up right around the time of the nationwide recall. same year. The Gauss case, G-A-U-S-S, I have no idea if I'm pronouncing it right, but you know, the plaintiff there alleged that the product had too much alcohol. I tried to figure out what the settlement was. The lawyers got a few $100,000, so that would be just the plaintiff lawyers got a few $100,000. It doesn't say how much the defense lawyers got paid, but that's, you know, part of the expense to the company. And in terms of how much, you know, what did the plaintiffs get, there was a very elaborate couponing system, but I think it was a 1-for-1 ratio. For every single dollar of sales with the kombucha company, the consumers that bothered to fill out the forms got a $1 coupon, up to about $6 per household or something like that. So it's a little hard to figure out the damages, but it's big money. Okay, then the next two cases, Patch and Fernandez, related to health claims. They got settled together, even though they weren't filed at the same time, and the amounts and structure of the settlement was roughly the same, very roughly the same as in the Gauss case. That last one I listed was again about alcohol. These are state cases filed in California court. Almost all the cases are California related. I think the law is more liberal out there. I suspect Justin and Will know a lot about the California situation and why it's so preferred by plaintiffs. This Withoff case had a similar payout based on similar facts and allegations that, you know, hey, this is kombucha, it's over 0.5% alcohol by volume, it's an alcohol beverage, it's not labeled as such, it's misleading, that sort of thing. The only thing that's really especially interesting about the Withoff case is the branded issue. And by the way, I'm not talking much about the brands. If you really want to figure it out, just go get the case and read about it. But it was a, shall I say, a large food products company, a large beverage company behind this last brand on this page. And they just chose to say, like, to heck with it. This category is a pain in the neck. And they bailed out of the kombucha business altogether right after this 2010 state case, and right after they paid a big penalty or a big settlement. So, sort of wrapping up, a couple more cases in the past 3 weeks. It keeps on going. In one sense, it shows that kombucha has clearly arrived. It's in the grocery stores. We've got this AHPA seminar. The congressman is all over it. And perhaps in our society, sign of the times, the lawsuits, like Tammy mentioned at the beginning. You know, it's almost inevitable when something gets so popular that it attracts attention from even the kind you don't want. One thing to notice, it's kind of interesting, is strangely these lawsuits have not been in the press, probably just a matter of time until they appear in the press. Let's see. These state cases, 2 of them are about alcohol content, the typical allegations we saw on the previous slides. 2 of them are a little bit new. They allege that the sugar quantities are wrongly stated on the labels, so it misleads consumers as to the sugar levels. The companies at issue, it's one big brand and one medium-sized brand. So really that's all I have. I hope this webinar has showed that the law has a lot to do to catch up with kombucha. Alternatively, kombucha has a lot to do to catch up with the law. Thank you for listening, and I hope to hear some good questions later.
Thank you, Robert. Certainly no shortage of regulatory requirements and other activity for kombucha products. Thank you for that. Next, we have Pete Evich to discuss some legislative activity. Pete?
Thanks so much, Tammy. As it's been mentioned, my presentation is going to focus on a piece of federal legislation titled the Craft Beverage Modernization and Tax Reform Act of 2015, and how this bill, if enacted, could benefit those companies who sell alcoholic kombucha, which is how I refer to finished product kombucha that has. Thanks so much.
Definitely, most definitely. So, and thank you to the panelists and for all the attendees for joining today. Consumers absolutely love kombucha products, and we appreciate everyone taking the time today to hear from the experts. For the attendees, you will receive an email with access to all the materials. There will be a follow-up satisfaction survey. Constructive criticism is always welcomed. And thanks again.